Welcome to IP Insights. Today we take a closer look at the service of the statement of claim in UPC proceedings. The principle is simple. Within the EU, the statement of claim is served under the EU Service Regulation. Outside the EU, the Hague Service Convention applies. On top of that, the rules of procedure allow alternative methods or places of service. Correct, Martin?
That's right, Ronja. And this exception is highly relevant because outside the European Union, sometimes it is difficult to serve defendants within a reasonable time or at all. Therefore, Rule 275, paragraph 1, allows the court to permit service at an alternative place or by an alternative method. This means the court can deviate from the convention or the regulation you mentioned. Furthermore, paragraph 2 of Rule 175 allows the court to order that steps that have been taken to bring the statement of claim to the attention of the defendant are good service. So in this case, the defendant is deemed to have been served. But of course, such court orders are subject to specific requirements.
Indeed, in both cases, a reasoned request of the claimant is necessary. Also, the alternative service may not contradict the law of the state where service is to be effected. Furthermore, Rule 275, paragraph 1 of the Rules of Procedure suggests that alternative places or methods of service are subsidiary, since it requires that service under the normal rules and regulations has not been possible. However, and that's where things get interesting, the second paragraph of this rule does not suggest a subsidiarity.
Yes, that's true. The second paragraph only requires that certain other steps have been taken. And those steps are then, in hindsight, deemed good service. But the hierarchy of the paragraphs is not entirely clear. It has been subject to two decisions from the UPC, one from the local division Munich and one from the local division Mannheim. And both take a different approach.
In the decision of the local division Munich, in the case Phillips versus Belkin, the service of the statement of claim on the UK and US defendants had been pending for 2 months when the claimant hired a private service provider which effected service on the defendants. The local division in Munich found this to be good service under Rule 275, paragraph 2. It thereby also found that alternative service under this rule does not require that normal service has failed. It is also possible if service initiated by the court is still pending.
The local division Mannheim expressly disagrees with this. In its decision Panasonic versus Xiaomi, the court argues that Rule 275 includes the following hierarchy. First, service under the Hague Convention or the EU Service Regulation has to be attempted. When this fails, the court can order an alternative place or an alternative method of service under Rule 275, paragraph 1. And only when this also fails, the court can issue an order under paragraph 2 and deem steps that have been taken good service.
The local division in Mannheim emphasized the importance of the Hague Convention as an international treaty which needs to be respected. However, the hierarchy between the first and the second paragraph of Rule 275 is at least not explicitly stated in the wording of these rules.
Yes, I agree. And if it can be established that the defendant has received all relevant documents, it is in fact a formality to wait until official service has been completed. In practice, service abroad can take several months, or in some places virtually is impossible. In such cases, there's a valid interest in moving proceedings forward. Justice delayed is justice denied.
In fact, the German national courts, and in particular the Munich courts, have adopted a practice to serve defendants in China via means of public notice. They have accepted that it is impossible to serve documents under the Hague Convention in China. It remains to be seen whether the more liberal approach from Munich or the stricter view from Mannheim will prevail at the UPC. It seems like a small detail in the rules, but its practical impact is very important for the efficiency of this new court.
Yes, we will certainly see more decisions on that issue, and I trust that a pragmatic solution will be found. Thank you for watching, and if you have further questions, please visit our website or contact us directly.
you.